Now let me talk about something that is developing. We haven't brought this to fruition yet. And it stems in part from this. It is a fact that the elected official has an oath of office. And his oath of office says that I'm going to respect the Constitution and what the Constitution means to your unalienable rights, and I'm going to protect that. Well, we have now the thought that we are going to send a negative averment, an affidavit that is formed in a negative averment. In other words, if I say I have evidence that you have violated my rights, then I have to produce the evidence. If I say that there is no evidence that you have not violated my rights, then you have to come forward and prove that you have not violated my rights. In this case, it would be silence. If you're silent in this case, you are acquiescent to my position that indeed you have violated my rights. Now, we're not going to take this to court because we know that the court's going to rule against us. We're going to go to the bonding company. In Alabama, if a public official cannot hold his bond or have a bond, he's out of office within 30 days. So if we can build a case where the principal, this would be the elected official, has sent a code enforcement officer and has harassed and harangued a property owner, private property owner, and we send a series of negative averment statements to him, first identifying who we are, looking for a signed written response within a reasonable amount of time, stating that your agent has come to a private jurisdiction and has caused this, this, and this to be done to that private property owner, and you have violated his unalienable rights. Now come forward and prove where is your jurisdictional authority to take such action. And he is silent, or he responds, and we look at the response and determine that it's not acceptable. Then we build a case over time, and we take that information to the bonding company, and we say to them, here's our evidence, we're going to go to court, do you want to stand behind this individual? And if they relinquish that surety bond for that individual in office, he's out of office, unless he can get another one in 30 days in Alabama. So that's very simply what we're aiming for, and we have officials that have violated rights. Now we're looking to do this at the local level against a very small, maybe code enforcement officer. We're looking to learn how to do this, and we're hoping to have this done, I don't know, within a year. It takes longer to do things than I ever thought it would, but I do know that there's a clerk of court that refused to transmit pleadings that were needed in an appeal. This person has violated someone's rights of appeal, due process violation. So that's documentable. We can document her actions. And I don't know whether that's going to be the first one or other cases where there was actually a case in North Alabama where they foreclosed, they being a mortgage company, bank, foreclosed on a property owner that was not behind in the notes. And the canceled check, the guy's got the canceled check, and on the back of it, it says transferred the funds to a specific fund within the bank and was not applied to the mortgage. After a certain amount of time, they declared it to be delinquent and moved against him for foreclosure. Well, the guy got up in court and said, first, I want to have the officer of the bank come forward so that I can cross-examine him and determine why the funds from this check were not applied against my mortgage. Well, they refused to allow him to have that cross-examination or examination of the officer of the corporate body that made the accusation that he was default in the contract. So now he's not only appealing this case, but he's going against the bonds for not only the judge, but the officers, the lawyers for the plaintiff.
I think the thing that we have to know is that we can't have liberty in their courts. We can only have it in our own courts.
We have to reestablish the fact that we can have liberty in their court, and we need them to uphold the tenets of their oath of office, which says that they're going to protect our unalienable rights.
That's interesting, because if they're taking the oath of office for their courts too, and they're in violation.
Yes.
Okay.
And we have to prosecute that.
Okay, no, that's, thanks.
Yeah, you're welcome. Any, Charles?
Yeah, I'm not sure how far you go beyond this, but how do you see this applying to some of these Agenda 21 comprehensive plan
most definitely.
Yeah.
The very first thing that I think ought to be done is a statement of who you are. and you could actually just put something simple on public record, that the comprehensive plan is in violation of the oath of office of all elected officials that have had, let's see, first, that signed this and adopted into law, and all of the elected officials that have come afterward that have not rescinded this, they are in violation, and I'm just making this statement public. Now, the next thing that you might want to do would be to send a statement of negative averment that the comprehensive plan is in violation of the tenets of the constitutions, both state and federal, and that you need to come forward and prove that it is not. My opinion about all this is that this has application for so many different things, but we need to start with some simple, very low individual. For instance, I know that one individual is talking about going against the county commission. And my viewpoint is, don't go against the whole county commission, go against one individual, and likely you'll drive that wedge, especially if there's validity in this, and the parties will step aside and allow him to be affected by this situation. Now, if that should work, then you could apply it to the other ones. But at any rate, if lightning strikes between the county commissioners, they step aside and they don't want to have anything to do with the lightning bolt coming back. So it may have a lasting effect on the other ones that are in office.